Well, the NBC News policy of shut up and leave has just been lifted. I'm Scott Ott, and this is Bill Whittle Now. And Bill, the announcement came from Rachel Maddow on MSNBC announcing that NBC Universal, the owner of the NBC News operation and MSNBC's news operation, has basically released any employees who believe they may have been sexually harassed or sexually abused from their NDAs, their non-disclosure or non-disparagement agreements. And Bill, I want to, first of all, get your reaction. Let me do that first. Let me just get your reaction to the idea that a major U.S. news operation has basically said, look, if you think you've got a claim regarding sexual harassment or sexual abuse, you are no longer constrained by your NDA agreement.
I am certainly not an expert. I'm not a lawyer. I don't know anything about the details of this. But from a philosophical point of view, it seems to me that if you have had a crime committed against you, your NDA does not protect the perpetrator of that crime. That to me seems like well beyond the call of what a contract between two individuals agreeing to exchange money for services entails. So on some level, at the very least, this is NBC coming up to at least moral sea level. And it may be legal sea level as well.
Well, this is interesting the way they stated this too, Bill. And this is from the NBC Universal statement. Quote, any former NBC News employee who believes that they cannot disclose their experience with sexual harassment as a result of a confidentiality or non-disparagement provision in their separation agreement should contact NBC Universal, and we will release them from that perceived obligation.
Okay.
Perceived obligation, Bill.
Well, that's a fair term for a company making basically a legal statement. Perceived in that case does not mean invented. What it does is it says, if you believe this happened, then we will release you from it, and it's neither confirming nor denying that it happened. So
no, this is not actually to do with, the perception is not having to do with the incident of sexual harassment. It's having to do with the obligation to remain quiet. It's that perceived obligation to shut up. So basically, NBC Universal is implying that they never had to shut up.
Well, again, that was my initial take, was that they never had to shut up, that somebody assaulting you is not protected by a non-disclosure agreement. First, in the first place, you could, without question, have a private lawsuit where you discuss the aspects of the actual sexual assault or whatever it may be, without disclosing anything about NBC's operations and so on. It's got nothing to do. The two are completely separate domains. That's why it's a crime. So I'm not entirely sure that this opens a whole lot of doorways to justice, Scott, but it does sound to me like the kind of virtue signaling that a company would engage in if they had the kind of catastrophe that they have on their hands with Matt Lauer and some other cases.
Well, and it's interesting here because the whole NBC Universal statement didn't really dwell on the specifics of any employee's allegations or even on the idea of a sexual harassment allegation. But the language seems to me to be beyond legal language, starting off saying anyone who believes they cannot disclose their experience. Okay, so this is the employee thinks they can't do it. And as I mentioned, the perceived obligation to remain quiet. But it says that this employee should reach out to their boss, to NBC Universal, and we will release them from the perceived obligation. Bill, why would anybody need to be released from a merely perceived obligation?
Well, not knowing the full details of the legal document that these people signed, it sounds to me that NBC is trying to come out and sound like they're fully supporting the Me Too movement because they've had at least one and probably several predators on their staff for 20 years. And every single day it comes out and gets worse and worse and worse. If I go shopping and every time I'm checking out of the grocery store, I see Matt Lauer's picture on the tabloids, this is a catastrophe for them. So I suspect on some level this is largely a public relations kind of move. Now, this business about coming and talking to us makes a kind of business sense. You can't just blanket release everybody from their NDAs. Essentially what NBC is saying, I guess, is that if you feel that something happened that is, not, inappropriate to the degree where it's punishable by law, or certainly by lawsuit, then what they're saying is, come talk to us, tell us what happened, and then we'll write you an exception on your NDA. But they can't very well just say that every single person who ever worked for NBC is now freed of their NDAs. And so they do have to kind of take it on a case-by-case basis, I imagine.
Well, the bigger question, why somebody who's under the I was going to say constraints, it's really a constraint upon government, but one who plies his trade under the protective umbrella of the First Amendment of the Constitution feels like they even need to sign agreements with employees that say, when you leave here, you can't say anything bad about us.
It's a sign of the times, and not a good one. The non-disparagement stuff is one of those things, Scott, that just got kind of slipped into the cake batter somehow. Somebody accidentally knocked some kind of olive oil or something into a chocolate cake, and it's like it's baked in now, and it's like it has been. See, this is how these kind of things work. This is how we lose so many of our freedoms over time. It's never with somebody coming out and saying freedom of speech is now banned in corporations. It's that corporations and other entities produce contracts that are so impenetrable that you simply sign them without understanding all of the clauses in the contract.
Because they're non-negotiable anyway.
Well, yes, basically, sign it or don't work here. But when a contract becomes so, just Babylonian in its complexity, then you could make a case, and I'm sure people do, that this is somehow not really binding because there's no way anybody could have read and comprehended this even though they agreed to sign it. Great example are all of these end user agreement things we get. You update your software on the iPhone or something, and do you agree to the terms? Yes. What are the terms? Who knows? Who knows? So on some level, what we've seen happen is we've seen the legal profession complicate business transactions and business relationships to the point where the only people that can understand them are the priesthood that are attorneys. And the counter to that is that more and more people are not even considering those kinds of contracts as even a contract. It's like, well, of course I signed it. Nobody can get past the first page of it. The whole thing is part of this. It's certainly not lawyering up in the traditional sense. There is a very strong tendency, and always has been, for people who have a certain amount of power to make things as opaque as possible to people who become their clients, because if they're not opaque, then they're not getting a check. If every single contract was a 2-sentence contract written in plain English, you'd have a lot of attorneys out of work. And so all of this seems to me to be just this ongoing, perpetual kind of kudzuization of what's a pretty simple transaction. But I do agree with you. It's not a completely clear-cut issue. I agree. If you work someplace terrible, you should have the freedom of speech to be able to say, boy, that was terrible. But at the same time, I can understand and sympathize with the private company that says, we are now going to allow you in behind our closed doors, and in exchange for that, you're going to see things that people in the public don't see, have no access to, and we don't want them to have access to.
Well, we don't want them to have access to proprietary intellectual property, but if you do that in order to provide a veil of secrecy behind which you can conduct yourself in a deplorable manner against your employees, how should that be protected? If
you really want to go and see really draconian non-disclosure, non-disparagement agreements, you really have to go over the hill behind me here to Hollywood and see the kind of contracts that you have to sign if you're going to be Tom Cruise's personal assistant, let's say, or somebody on that level. Those things are so constrained. It's just almost unbelievable. I'd really like to get to the larger issue, I think, if I can. And the larger issue comes down to things like prenuptial agreements. And it seems to me from a geostationary orbit point of view, looking down on society, it seems to me that what we are doing over the course of the last 50, 60 years or so is replacing virtue with protection clauses. And every time I hear a contract that says, and forgive me for mangling this, but every time I see a contract or sign a contract that says, I hereby assign to the assignees my image reproduction, and it's like every single possible thing it possibly could be.
In perpetuity.
Into perpetuity and so on.
In the entire known and unknown universe.
Yes, exactly. And so whenever I see a list of things that are like specifically spelled out, laundry list of things that this one particular clause in a contract means, I realize I'm dealing with people that are trying to shut loopholes. And I don't generally like working with people like that. I mean, I'm not saying that every single business should be conducted on a handshake, certainly not. But I do think that a contract should primarily be written to make it clear to both parties what the actual understanding is. That, I think, is the primary benefit of a contract, is to simply say, all right, we both agree on this and we sign it. It's not like, well, I assumed you would do this. Well, you assumed I would do that. Well, here it is in writing. That's, in a healthy society, that's the primary value of a contract. And living in a pretty healthy society, as we do, you still have to face the fact that there are people out there who are just plain crooks. They won't pay.
Bill, it's our progressive buddies over at MSNBC who have taken the lead in this matter. Meanwhile, as we record this, the folks at Fox News who are constrained by such NDAs, including people like Gretchen Carlson, who had an out-of-court settlement, basically because of her claims against former and now deceased Fox News president Roger Ailes. There are several Fox News employees who cannot speak publicly about what happened to them because they're still constrained by them. One of them released a column today that called on Fox News to follow suit with MSNBC or NBC Universal and to do the same thing. Let me ask you, should the entire media industrial complex, so to speak, as well as Congress, release all their employees and frankly, for Congress, open the records and say, here's the hush money payments we've made? After all, we had a big stink about Donald Trump's hush money payments to Stormy Daniels and Karen McDougal.
Transparency in government, to me, is not up for discussion from a philosophical point of view. There's nothing that the government should do that the American people cannot look at instantly unless it is an extraordinarily limited set of military or intelligence operations or assets that to compromise them would significantly harm the country as a whole. But in general, I don't think that there should be anything. I think the greatest stroke of freedom, I think there's no question about this, none. The most amazing stroke of freedom since the Constitution was the Freedom of Information Act. And that was an astonishing thing, that you could actually file a petition and get James Comey's emails delivered. That's very, very good. A company has a right, I think, to silence. Look, Scott, we should get to the brass tacks here. When I have somebody who is very close to me who was a victim of a sexual harassment suit, and it really, really who filed a sexual harassment suit, and the activity had really messed her up emotionally badly. She took years and years to get over it. And so what happened was they had a settlement. She got a check to compensate her for the damage that was done to her. And as a condition of the check, she agreed to basically not discuss the details of what had actually happened. So on a lot of levels, this really is just hush money. And to be completely fair about this, if you accept a cash payment as part of a deal rather than as a jury award, then you are making a decision on your own as an adult. Is the ability for me to go public with this more important than $200,000 or whatever the case may be? So it's hard to find fault anywhere in that particular aspect of it, really, when you get down to it. Now, obviously, every single person who has a legitimate sexual harassment claim, including my friend, has the option to say, no, we're not going to take the settlement. We're going to trial with this. And if they go to trial with it, then if they win, they not only get whatever awards, but then they probably get the ability to talk about whatever they want to. But the point is that in most cases, most people would rather just simply take the restitution or the compensation or whatever you want to call it and put the thing to bed. The only thing I see here— It's not
just to make it go away, Bill, though. It's also because they're going up against a multi-billion-dollar media conglomerate that can literally destroy them, who has an entire staff of attorneys devoted to digging up dirt about them to discredit them in court. And no matter how strong you are in your conviction, no matter what you believe really happened to you, it's hard to stand up as one person against all of that.
Which is why most everybody takes the settlement, because they're fully aware of this. And then the companies have got very skilled people who have determined what kind of payout we could make that would be in our interest to make, and it's usually way less than what they would pay if they went to court. But the point you make is an excellent point. They don't even have to dig up dirt on you. All they have to do is make sure that the trial lasts 10 years or 5, because they've got attorneys who are being paid every single day, whether they're working on your case or not, and you don't. And the only way you can actually survive that kind of thing, if you really wanted to go to the wall with it, is to find an attorney who felt that your case was so compellingly clear that he was willing to risk 5 years of work without compensation in exchange for a third or whatever of the jury settlement. But all of this is, look, all of this kind of stuff, this kind of tort stuff, is essentially a form of horse trading. And that's what it is. It's saying, you did this, as I'm speaking as an employee, and I'm generalizing, needless to say. A person in authority over me, working for your company, did this to me, and this is a crime, and it's egregious, and it's an assault, and so on, and I'm damaged by it. Then the company says, okay, what's your proof? And then you show them the proof, and then they say, okay, that is actual pretty good proof. We're going to make you an offer. Maybe you say, well, no, I'm not taking it. Maybe they'll raise the offer, whatever. Then the person who's been damaged has to decide whether or not they want to risk the money that's on the table. It's almost like a game show, I'm sad to say. Whether you want to risk the money that's on the table for 5-year legal battle or 10, which may or may not go your way, and which may in fact conceivably end up with you having to pay the court fees and so on. It's a form of
continued sexual abuse.
Well, yeah, Scott, that's actually a really good way to put it. That's really, really good way to put it.
Ladies and gentlemen, Bill Whittle Now is made possible by the members at BillWhittle.com, who not only fund these productions, but as of this week have begun funding the distribution of the new audio version of Bill Whittle Now, and also of our other show that we do 5 times a week, Right Angle with Stephen Green, in addition to Bill and I. You can listen to that podcast on your Apple device, your iPhone with the podcast app, as well as on Google Podcast and any other podcast player you use. Just go to BillWhittle.com and click the podcast link. If you'd like to join the members who are funding these enterprises, then just go to BillWhittle.com and click the Become a Member link. So for Bill Whittle, I'm Scott Ott. Thanks for watching.